Hi guys, I am back doing a live and I've got you on both channels, on Secondary Sisters and obviously my personal page, Boobless and Beautiful, because today I'm here talking about a very important topic, wills. Now, we don't discuss these sort of things very often. I think we're very good at talking about all the sort of little stuff, but actually these are quite big things that we probably don't talk about as much. So I've got the lovely Rachel here from Foster's Solicitors, who has done my will, and we're going to answer lots of your questions because you've all written in loads of things I didn't understand about wills, so this one's really helped me. So hopefully we're going to have a discussion about this. Anyway, hope you are... Oh, I don't know what's happened here. Hang on 1 second. I've got create a room to others. Don't want to do that. 1 second. Let me put that off. It's telling me all sorts of stuff. Let me go off that. Right, let's crack on with getting some questions which haven't come up. Why haven't they come up? Oh no, hang on.
People are joining.
Oh no, I should have written them all down. Right, okay, so for some reason the questions aren't coming up. Good job, I've written some down here, and we'll probably just go through a lot of things about the will. So if you've got questions, please put them in the comments and we'll make sure we answer those for you. Yeah. Okay. So
yeah, anyway, I'm delighted to be obviously speaking with Laura to all you guys. It's amazing, and I'm so excited that everyone wants information about wills. I'm often branded as the doom and gloom angel of death. It's all I talk about, but I am very passionate about getting people's affairs in order for what is inevitable for everybody. I wish we could have a more frank discussion about it, if I'm honest. So I'm here to hopefully put at bay any concerns you have about making wills, about the process, hopefully offer a friendly face to the what is doom and gloom, and yeah, feel free to ask whatever questions you like. No question is is silly. I've heard it all, to be honest. I've been working in this area for nearly 10 years. So you wouldn't believe what I've come across, but I just want to be here to kind of impart some knowledge on you guys. So
fabulous.
Yeah.
Right, so we've already had a question just in this bit. We've got some written down from what was put in earlier. I think because my question box was slightly over the 24 hours, it hasn't popped up, but I think I can remember a lot of them anyway. So who needs a will? Is it just for those who own a home and have money?
Right, so you don't need to own anything to have a will. That's the myth. So generally speaking, your biggest asset, or the most important reason to have a will, is to make sure that what you do have, it could be debts, it could be minimal, it could be your clothes, it could be your CDs, whatever you have, goes to the right people. It's also really important to name guardians for any children under 18 that you might have. That's hugely important.
That was one of the questions that came up, I think, is if we've got kids, how do we work that one out? And I think it's, a lot of people don't think about that, do they? They don't think because you kind of just expect them to maybe go to, say, a parent or something, but actually some people might want them to go to a friend, and how does that work in terms of if you, say, choose your best friend as the guardian, would they then have to go through, say, an adoption process for that child, or would they literally be legally kind of then entitled to...
Yeah, so because the will is a legally binding document, whoever you name as your guardians, they will become responsible for your child at the point of your death immediately, without any court application.
So make sure they know about it as well.
Make sure they know about it.
Otherwise it could be quite a surprise.
I mean, our recommendation is name a first choice and then put down a second choice, because you wouldn't believe how many times people's circumstances change. They may have been willing to accept your 3 kids and 3 dogs 10 years ago when you wrote your will, but at the point of your death they may not have the space in their home. They may be going through difficult times, so have a replacement.
Yeah, and it's always good, I suppose, to go through these things every year or a couple of years just with the people, especially for things like children, because it's such a big commitment. It isn't like you're just giving over a box of jewellery or something. I think, when it is children or animals, I suppose that's the same with animals, is it?
Yeah, same with animals. Animals is, again, you can put animals in your will. We don't recommend actually naming your animals, because with animals having a shorter life expectancy than ourselves, unfortunately, we tend to say just generally refer to my pets. Whatever I have at the point of my death, I want them to go to X or Y, depending on who works. Yeah.
Perfect.
Yeah.
I'm just going to check this one because I saw a couple of things pop up. I just want to see if there's anything.
Keep the questions coming.
We've got some written down, so we're going to start going through a few of those. So, do I still need a will? I thought everything was left to my husband. So this was obviously a question that, people just expect everything to be left to the husband. Is this the case? Or what happens if, I think we've had this discussion before, if the husband had something wrong beforehand and then they haven't updated their will, then what happens to the to their will?
That's a very good question. So again, a very common question actually. So the government do set a list of who can inherit from you in a specific order. Husband is top, second is children, and then it goes down the list, so on and so forth. One of the things is, yes, if you are married and your circumstances are straightforward, you haven't got children, you perhaps own a house jointly with your husband, you won't necessarily need a will there and then. There's no urgency to have one set up. But our recommendation is to have one set up because it makes life a whole lot easier for your husband when if he's dealing with your estate, to have a will in place, because it means he then becomes your executor. He becomes entitled to deal with your estate straight away from the point of your death, because there's a will to show that. Without a will, he's got to go through the courts and apply.
Proof with marriage certificates.
There'll be a certain degree of proof he needs to provide to say that he is entitled to be your executor or your administrator and deal with your estate. So our recommendation is have a will, don't leave anything to chance. And you might find through talking to myself or one of my colleagues that your circumstances are a little more complex than you realise. So don't leave anything to chance. Don't leave the loved ones in a difficult situation. You know, it isn't hard, I promise. I've done my own will. Laura's done hers. We've all been there.
So quickly, there's one here saying, if you have separated, and this is obviously quite a complex one, if you've separated, can you list that you want your child to go somewhere else, or would they have to go to your ex?
Yeah, I mean, that again, I've come across that a few times before. So if your ex, God forbid, is not the type of person you feel would be appropriate to raise your child, I've done wills for people before where we've said alternative people like parents or brothers and sisters. The one thing you have to bear in mind is your ex, if he's got something called parental responsibility, which means he's jointly responsible for the child with you legally, he is entitled to challenge what's in your will after your death, and he can bring an application to
So
the
if he's the
court.
biological dad and actually still part of the child's life to a point, it's really hard to then not have...
It's very hard, yeah. And you can't remove parental responsibility you can't take it away from a father unless you go through an application with the court. So one of my pieces of advice about this is, if you don't want your child to go to your ex, then you would need to prepare a will to name somebody else, and I would prepare a sort of statement from you to say why your ex isn't suitable and why your parents, for example, are more appropriate. And I would put together evidence. So if, God forbid, you've had to have the police involved, if, God forbid, child services have been involved, there'll be statements, there'll be reports, and we can file all of those with your will. So if your parents, let's say you've chosen your parents, have to defend your ex in an application, they've got all the evidence up front. So that's the kind of thing we do. I mean, I've done quite a few, so it's a horrible situation, but we can get around it. Okay,
so obviously sort of one of the questions that came up a lot was, how do you do a will? What is the process of doing a will? What do they need to provide or talk to you about? Talk us through that.
Okay, so we do a sort of Q&A at the beginning, and then we go through your instructions for the will. And the Q&A will be, I suppose, part of making a will is we need to know what you have asset-wise, we need to know who your family are, we need to know a bit about your background, your marital status, all those sorts of things. We're also looking within your circumstances of people who might want to challenge your will. So that's why we like to know if you've got any children, because if you don't leave anything to your children a will, they can challenge your will. If you've got a husband you don't leave things to because you're separated, again, they can challenge the will. So I'm looking for all of those things in the Q&A session. I'm also checking to see whether health-wise, how much time do we have to get this will done for you. I've done wills I've turned around within an hour at someone's deathbed. I've done wills that people were happy to sit on for a year, so we work to what your circumstances are. And then, as I say, then I'll ask you the questions going through the will from top to bottom. Who do you want to be your executors, the ones in charge of making sure the will is carried out? Do you want to put any funeral wishes? Are there any specific gifts you want to leave to anyone? Charities, family? And then we'll talk about guardians if you've got children under 18. And then finally, we'll talk about who's going to inherit the balance at the end. And then we perhaps we go sort of a bit deeper and we say, what if that person isn't alive? Who's the next choice? So that's how the process works. And then I go away and draft the will as quickly as you need me to do it. I send it to you to approve, and then we meet again and we get it signed. It can be done long distance. We do like to meet you at some point, so we can take initial instructions, Zoom, telephone, however you like, and then we like to meet you face to face to sign. But if that's not possible, we just ask you to sign a disclaimer to say you haven't met me, and that's fine. It just means your will is ever so slightly less secure, but that's not a problem. We're talking from 100% secure if you come and meet me to 95% secure if you don't. So it's just something.
I think that's really important to say as well, because obviously this page, I talk about secondary cancer a lot, and also on Secondary Sisters, there's a lot of people here that are diagnosed and then go, I need a will. And you don't, and obviously, unfortunately, there are people that don't have very long. So it's good to know that it can be turned around quickly, because some people don't have that time. And if you haven't had a will, it's then a process of getting a will at that point. But it's good to know you can do it, although it's better, as you say, to do it in advance. And I think, obviously, I've done my will with Rachel. And it's a really simple process, and it was, even down to things that my will is my main, what I want, but then alongside my will, I've got my wishes. And obviously my husband is my executor of my will, and he can hopefully, spread out all the things like my jewellery or bits I want, things that I own that I want to go certain places. And that's really important, just you can still have wishes without them being actually in your official will.
Yeah, that's right. Yeah.
Could you explain about trust funds for gifts or inheritance?
Oh goodness, right. So trust funds.
We're going deep.
We're going very deep. This is complex, isn't it? So trust funds are normally for children who are under 18, or for people who are disabled or have mental health issues, so they wouldn't be able to manage the money themselves that you leave them. So it goes into a trust, which means it's bubble wrapped and protected, and it's managed by 2 or more people known as trustees. So they're in charge of the money. So if the child, let's say they're 12 or 15, so they're 16, 17 and they want driving lessons, but the fund is held for them until they're, say, 30, they can ask the trustees who are managing the trust whether they can have a little bit early for driving lessons. The trustees may say yes, they may say no. I'm sure they'll say no if it's for something like a Ferrari or something, or a Rolex watch, which probably won't benefit. They don't need. So, the idea, we try, and when money's held in trust, we try and find out what the objective of the person who's putting in trust is. So are they wanting to have a fund for their children to be able to buy property when they reach the age of entitlement? In which case that will be communicated to the trustees. So trust funds are great, but they usually are only for those specific purposes, for people who are, say, unwell and wouldn't be able to manage the money, or children under 18. They do, as I say, we are happy. I'm very sort of accustomed to putting those in place. So if that's anything you need, just let me know.
There's one just popped up here. Click. Even though I am the sick one, do I call a lawyer to do a will?
Okay, so we can have the initial inquiry from anybody. So for the purpose of the setting up an appointment, anyone can call on your behalf and make that appointment, and we can come to your home, we can meet you in hospital if that's where you are, we can come anywhere, and we can take instructions from you about the will. So we just like to see you on your own if possible. So there's no problem with someone else making inquiry for you. All right, hope that helps.
So let's go into a couple of the questions we had, which obviously are quite relevant to each other. Firstly, how much is a will?
Ooh,
and secondly, how or what are the choices if you can't afford to have one written up?
Okay, so generally speaking, prices will vary. Everyone has to say that, that's my disclaimer. So our sort of more straightforward wills for existing clients of the firm usually start from about £300 plus VAT, and they can go anywhere upwards to nearly £1,000 plus VAT if you've got wills for couples with lots of complexities and trust funds. So that's kind of the range really. But if it's a straightforward single will for one person who's an existing client of Foster's, or has already got a will at Foster's, it's £300 plus VAT. So not a huge spend when you think about you're protecting all of your assets to go to your loved ones, and you'll have that peace of mind. So yeah.
Let me just pop. There's one that came up on our second sisters.
Oh, I didn't ask the second part of it.
Sorry. Yes, and how do you?
If you can't afford a
one?
will, absolutely, really good question as well. So a lot of firms subscribe to something called Will Aid, or do their own charity will schemes. We used to run one in November. We will probably look at reinstating it, and it's where what we do is we charge. Well, we reduce the price of a will, and instead of the fee being paid to our firm, it goes to a charity on your behalf. So it's a much lower fee, and what's nice is that you know you're giving, and we always support local charities in doing that. So we may reintroduce that. You have to watch this space. we'll look at that.
We'll keep you updated if that happens.
But otherwise, I mean, you know, it's a tricky one really, because you don't really want to sort of go down the route of a W.H. Smith will, which I've heard people do, and they can go terribly wrong, and I've had to unfold a lot of problems from those. So I would say, you know, we can say that they're generally the prices. We definitely offer sort of staggered payment schemes, so if that helps, we can stagger payment over several months. But I'd say look at a will aid scheme and see if there are any in your local area.
Lovely. Right. Let me just read this one. If your current husband has a child with a previous partner, and we now have children together, so there's obviously step siblings, how do I keep my money to my children and not going to his child? Because obviously, presumably that money would then go over to him and then down to his children, but obviously she would want it to go.
Absolutely. So in your situation, we would probably be suggesting a type of a trust, which is called a life interest trust, which is where instead of you, say if you passed away first, and you wanted everything to go to your husband, we would say instead of him inheriting outright from you, he would just acquire what's called a life interest. So that means he'd be able to enjoy full use of all of say the property that you own together. But if he then passes away, that part of the property that's yours will bounce back to your children and not go down his line, and then he can do the same with his part of the property and his assets as well. It's normally something we just do with your property though, but absolutely I deal with sort of blended families all the time. You wouldn't believe how common that. I'd say probably
a lot of them, I'm sure, have complications.
I mean, I don't often, I deal with the more complex sort of wills, and I'd say, you know, the complexities do come from your family setup, and more families are similar with children from previous relationships, so we know how to deal with it. But come and see us, and we would recommend a type of trust fund for you, which I do routinely, so I'd absolutely be happy to talk about that with you.
So going into other sort of areas as well, I had a question that was, do I need a power of attorney as well if I have a will?
Right.
So
the short answer is yes. So I don't know how familiar you are with power of attorneys, but power of attorney is where you nominate somebody to make decisions on your behalf if you can't make them for yourself. So they are a lifetime document only. The moment you pass away, that document is revoked, and it's what's in your will that is effective. Okay, so it's lifetime lasting power of attorney, will on death. So I would absolutely be thinking about a lasting power of attorney.
Especially if you're in a situation where you're poorly, because obviously that situation is, you know, you might get to a point where you can't make those decisions, or, you know, you don't want to have those sort of hard conversations, and they're at least able to make those decisions for you.
Absolutely, yeah. You do not want, I mean, if you're in hospital, if you aren't able to make decisions, if you're, you know, the worst thing you can do is not have an appointed person as such a power of attorney, because there'll be things that crop up. I guarantee you, bills will need paying. Your care may need paying if you're privately funded. You know, your partner may need to sell the house that you jointly own. Maybe they need to downsize. Maybe you can't. You know, and all these things they wouldn't be able to do without a power of attorney. The only option in that situation is if you were too poorly to make any decisions on your behalf, is your partner or your closest family members would have to apply to the court for something called a deputyship order, which is expensive, takes a long time, and you don't always get what you want out of it. The court generally make a really limited, they give limited power, whereas a power of attorney, you guarantee the person you've chosen will make the decisions for you. So absolutely. We do a really competitive package for doing wills and power of attorneys, and it would be absolutely something I would talk to you about if you came to do a will with myself, for example. So yeah.
There was another one that cropped up here.
Ooh.
My parents live with me and my husband. If I die before my husband, I want to safeguard my parents. I know my husband wouldn't ask them to leave and sell up, but I want them to have peace of mind. And obviously, what we think of won't happen as much as while we're living in that situation. I suppose once upon death, that he could have the rights to say, I don't want you living here anymore, and you hope that's not going to happen.
Yeah, I mean, we hope that you never know. He might, God forbid, meet somebody. He might, but from external pressures from other people, he might.
So would she then have to almost leave her half of the house to her parents? So then they have that security of the ownership of the house as well?
Well, actually, so if the ultimate person who you want to benefit from the house is your husband, but you want your parents to be safeguarded while he's alive, or while they're all living together, the best would be to leave your parents a right of occupation. So it'd be a right to live and enjoy use of the property after you pass away. You could do it for a limited period. You could do it for the rest of their lives, for example.
So he couldn't sell it under their feet if they're still living there?
Absolutely not. So so the will would give them all the protection. This is if the property's in your sole name, that is. If the property's in your sole name, parents are living it, husband's living it, you offer the protection to your parents. You could also put your husband in there as well to give him a right of occupation. So all three of them have got this right to live there.
And what if her and husband share the occupancy of the house?
Right. Well, if they share the ownership, so we'd suggest that then your half in the house. So we would separate your half. It's a bit complicated.
So their half would then go to the parents, or her half would then have to be secured for the parents?
Yeah, so your half would have to be secured for the parents via a right of occupation, or we could do a trust, like we talked about earlier, life interest trust, so they can enjoy use and benefit, but they won't have any sort of entitlement to it, ultimately, to the capital of the property. And then your husband does with his half as he wishes. But it is a bit muddied if you've got 50-50 ownership, because if husband does want to sell, yes, he has got to sort of bear in mind that, your parents have got this right of occupation, but it's a 50-50 ownership. So if there's 50-50 ownership, one party can force the sale via the courts. Courts are unlikely to to allow that to happen if there's a right of occupation in place, but it is an option. And if his situation is extreme, like for example he's been made bankrupt and they need to recover his half, his money that he owes from his half in the house, it could be that it might be successful. But so yeah, that's a tricky one. If it's in sole ownership, they're a bit more protected, but a jointly owned property, your half, giving the right of occupation, they're probably the best you can do.
Yeah.
Yeah.
So we had one that was said, how many times can you change a will? Is there a limit?
Ooh.
Can you change it regularly?
There is no limit at all, I'll tell you that. I have
every month.
I have some clients who I call the serial will writers, and that's not an unkind phrase in the slightest. They're lovely people, but every year they change their mind and they'll come back, and I've got a pile of all their old wills. So they can come as many times. You can come back and change your will as many times as you like. Once you've done your first will, it's fairly straightforward to then change if you want to just make small minor amendments, increase amounts to maybe allow for grandchildren, or as your life progresses, any changes. They're quite straightforward to include in your will, and we do them by way of a codicil. That's an annex to your will, and it changes just one or maybe two simple aspects to your will. If you're wanting to start from scratch, let's say circumstances have changed completely, you've met someone else, and you've had kids with somebody else, circumstances really have changed, then we'd recommend a full rewrite. So yes, but you do get that kind of previous client discount with our firm anyway, because you hold a will with us already. Okay.
I changed mine recently and it was very easy. So I set my will up, oh gosh, when was it? 5 years ago. When I first was diagnosed with my secondaries, I didn't have a will, and I wasn't at that point married, and my mum had just passed away, so I had some inheritance there. And so at the time, my will was one way, and I didn't make many changes. I made just a couple of small ones, but actually, it's now to do with my life now, because my life's slightly different. I'm now married. I've got slightly different, I suppose, the way we're living, and my mum's inheritance isn't as big as what it was because I've spent a lot of it. So, there's lots of little changes. And I think, my sisters, I'd left a bit more for them, but, they're now married and got their own sort of lives. So I feel that, you're in different places, I think, especially when I was 28 and now I'm 33. So it's always good to have a review every so often, or at least go through it, because there are sometimes, like I say, little tweaks, and it makes a big difference. Because I had originally, my will was set so if I got married it wouldn't have changed, so I wanted to obviously change that. So obviously because I'm now married, I want it to be more about that. So yeah, it's very easy.
It's very easy to do, absolutely, yeah, definitely.
And luckily you don't need to know the legal terms, these ones do.
No, I mean, what we do is we do appreciate that some of the will is written in quite heavy legalese language, that's what I like to call it. So what we do is we give you a full explanatory, very clear letter to go with it, explaining exactly what's in your will, so you can just read that if you want to, and then we go through it top to bottom again when you come and sign, to make sure you understand everything and you're happy with the implications. So yeah, but yeah, it was great. I mean, I was very happy to help Laura. I mean, after her secondary diagnosis, I felt I wanted to do something, and that's part of what I'm passionate about. Is I want to help people to get their final wishes recorded, because it's so important.
Yeah, I hadn't even considered a will before that, and I think it really made me think, gosh, if I'm not here, I don't know, where anything goes. And I think the other thing we were talking about when I set my will, again, was if, hopefully this won't happen, I mean, I don't want it to, if Brad passed away before me, his will is, so obviously it would go to me, but if I'm not in the picture, he's got a mum, and he's got a dad somewhere, he doesn't know his dad, and he's got step sisters and brothers somewhere. And I had absolutely no idea that his mum, because I would have assumed his mum would get everything. But you were telling me actually it wouldn't. It would then be
50-50 his mum and his dad. So
and
yeah,
if they went around, his brothers and sisters he's never met. So it's kind of very complicated actually. You don't really know it, or don't think about those external family factors where you don't even know the family. You think, oh, they've got nothing to do with it or can't come after it.
Exactly. Just because you don't have a relationship with one of your family members doesn't mean they aren't entitled to inherit under your estate if you die without a will. So that's why take control, make a will, make sure that doesn't happen. And as I say, we go through the levels of different people who can be entitled. So we'll say, right, who's your first choice to inherit? If they're not here, who's your next choice? Who's your choice after that? We can go through as many layers as you like and make it really future-proof. But yeah, I mean, in Laura's situation, when she wasn't married, Brad had no entitlement at all to her estate.
So my family would then be entitled. And
exactly,
then
it would have all gone to Laura's parents. That might have caused problems for Brad. We just don't know. So Laura wanted to safeguard Brad by making sure he was in the will. Same with as an executor. There's no entitlement for an unmarried partner to be your executor or in control of your estate. It would be your next of kin according to the government rules, which would, in Laura's case, would have been her parents, her mum and dad at the time.
Is that, I mean, you might not know this one, but is that the same in, say, a medical term? So if I was poorly in hospital and I wasn't married to Brad, would my dad, for example, get the overall riding say on my health over me? Over Brad?
That's a little bit more of a grey area. So usually medical practitioners will take into account the views of those who they class as your closest relatives. It's a little different to the government rules in inheriting.
Yeah.
But yeah, husband would be classed as your priority, I'd imagine, for medical decisions. But that's why it's important to have a power of attorney, so you can stipulate who is to make those decisions for you. So you aren't just leaving it to chance, because to be honest, the doctors, you might get one doctor one day that will say one thing and one another day that will say something else. Whereas if you've got a hard, fast, legal document saying, like in Laura's situation, Brad's to make decisions for me, then that's great. You've got it all sorted.
And you hope those people are going to take your best interest, whereas someone like, I don't know, if you've got a family member that doesn't know you that well, but is then entitled, then you don't want them making decisions on your health when they maybe don't know you that much.
That could be quite frightening, couldn't it?
Oh gosh. And also, I suppose if you're in a relationship that maybe because some people are in relationships that they're maybe not that happy, but actually, would you trust your partner to make those decisions right if you're not in a happy place? Because some people are together because of children, or they can't get out of a relationship, but actually if you had it in your will or the power of attorney that it was someone else, then obviously that then hopefully again safeguards you for if something was to happen and you're not that trusting of the person that you're actually married to. Because how does it work if you're split up but you're still married?
So do you mean for power of attorney or do you mean for wills?
All of it. So if you're actually still married but you maybe haven't been with the person for 2 years because you haven't had divorce yet, does it still if you didn't have a will, it would still entitle that person.
Absolutely. So yeah, because marriage is a legally binding contract, they become your number one. So for wills purposes, so we're talking about death purposes, if you don't have a will and you pass away and you're still married but separated, everything will go to your husband. He may have a new partner that might make you feel very uncomfortable to even think about. So we're talking over and above children.
So it would go over children first.
Over children, yes.
So it's really important that if you split or separate, get your will sorted.
Absolutely.
Before you, even if you haven't divorced.
Absolutely. It's one of, so we work very closely, or my department work very closely with our matrimonial department. So the moment someone comes in having separated, the first thing they're referred to do is make a new will to cover them between that period of separation and until they can get a divorce. A lot of couples don't get divorces and they don't realise the implications.
Or it takes time, doesn't it? Because obviously, you know, divorces aren't overnight jobs. They can take months and months, and people can cause problems. And actually, the last thing you're probably thinking of is, oh, my will, this. But actually, if something did happen in that time, you want to know that, as you say, it then goes to your children rather than someone that you're maybe not happy about having.
Exactly right. Yeah. So it's all about take control.
Yes, sort it out.
What you want. Yeah.
There was another one that popped up. Can you put details in the will about custody of your children? Oh, I've gone through this. In case my partner died, or is this solely to do with financial assets? So yeah, we did go over this a little bit earlier. So if you watched back, but we were talking about the fact that actually, if you do have it, you can put your so basically say anybody, can't you, in your will for custody?
Yeah, absolutely. Yeah. So they'll be in there just in case you and the father passed away and they were under 18. You could put down who's going to be taking responsibility for them. Absolutely.
How do people find out you have a will? Just thinking, if you're with someone who doesn't say you have had one. This came up with another question as well, was where do you keep your will? So do you have to tell someone you've got it? Where do you keep it? Like, how do people know that you've got a will? Or how does it work when you do die?
That's an excellent question, one we get asked all the time. So we recommend you have your will stored at the solicitors or wherever you make your will, whether it be with a will writer, have it stored there. That means it's protected. We store ours off-site in a secure storage facility where it's fireproof. It feels like it's nuclear-proof. It's pretty indestructible. If you have it at home and you have a fire or a flood, or it gets destroyed for whatever reason, that's it. That's the will cancelled. So keep it stored with your solicitors. The other thing is, it's always good to let the people in your will know that they're in your will. So we're not talking about your beneficiaries, the people who are inheriting. We're talking about the executors who are going to be in charge of everything ultimately. Let them know where your will is stored. And then if you update your will later with another firm, let the old firm know that you've done a new one, and we will collect in the old one for you and keep it all in one place, and we can have it destroyed here. So there should be then no confusion. There is such an entity called the Will Registry, which is where people were lodging their wills and you have to pay a subscription, but it was found not to work so well because not every firm was subscribing to it. So if not every firm subscribes, it doesn't work. So our suggestion is lodge it with the solicitor and keep a track of any
And how many
wills.
copies? Like, is there literally just one copy, or can you have two copies, one at the solicitor's, one at your house? Like, how does that work?
Yeah, so we always keep the original, so we're talking the wet ink original one here in our firm, in the off-site storage place, and then we send you a copy of the signed version for you to keep at home, and then we just recommend you review that copy every 5 years or after any major life-changing event.
So is the copy one still as legal as the one you keep?
It's not.
Okay.
So you can use a copy will after someone's died, but it is a more complex process. That's why having the original stored somewhere safely so it can be used immediately after you've passed away is really important. So yeah.
I had a question pop in about, so these kind of are quite similar. So is the process of wills and executives different in Scottish law? And also I had another one here about, let me go back to it 1 second. It was about America, I think. Do European American laws mirror each other in the power of attorney? So yeah, how does it work across the seas, if you know, obviously?
I mean, so one thing I don't pretend to have any expertise in is international law, European law. We only, here at our firm Foster's, we only specialise in English law. I'd imagine Scottish law is slightly different, but what would happen is you would make a will if you have Scottish assets, you'd make a will with a Scottish lawyer, probate lawyer, and then you'd maybe have another will in England to cover your English assets. So 2 wills can coexist,
Okay.
and we recommend having one in each territory where you own property.
So if you do own a property abroad, South France or Italy or something, then you should have a will in that country of origin.
Yes. Yes,
to kind of
absolutely.
Just
Because the jurisdictions are so different, the laws are incredibly different. You need advice in both. Absolutely.
How can I get a copy of a revised will that other family members will not reveal to me?
Okay. If we're talking about a copy of a revised will of someone who's died, that's a bit different to one who's alive. So
I presume it means there's someone that family members won't reveal the death one.
Yeah,
I
I'd
assume
imagine
that's what this
we'll
is,
go down the route.
yeah.
So when someone passes away, in most cases, and I say most, we're talking maybe sort of 70 to 85% of cases, the will become a public record after they've died. That's because it has to go through a process known as applying for a grant of probate, which means it's lodged with the courts and the courts will then upload it online and it is visible to anyone. You may have to pay a small fee to download it from the internet. Probate can take a little while to apply for. So if someone's immediately died, you're not going to straight away be able to see the will unless the executors allow you to see it. But if you're prepared to sit on it for a few months, there is, if you were to type into Google, there is a .gov website. If you type in find a will, it will link you to a .gov website where you can put in the surname of the person who's died, the year that they died, and it will take you through to a list of all those people with that surname who died in that year, and then you can go through and obtain a copy of their will. So it's really, I use it all the time. You wouldn't believe how useful it is, and it's a government service. So that's one thing as well to be mindful of, is your will could become public record. So
don't be too horrible.
Yeah, don't be too nasty with what you feel. Exactly. Yeah. So
yeah.
If you've got kids and you decide to leave everything to the cat's home, they probably will find out ultimately. So yeah, so I hope that's helpful. But as I say, we can help with any of that if you need any further advice on it.
We did have one that cropped up, I can't remember if it was on here or thing, about someone was saying they've got a partner with a student loan debt. Mm-hmm. Now, if that partner dies with that debt, does it then automatically become the other person's debt, or does it get written off at the point of death?
So it does depend. So each debt is different, but from my understanding, I've actually never dealt with an estate where there's student loan debt. My understanding of it, having student debt of my own, is that it dies with you.
Okay.
So that's one thing to put your mind at rest. But with other types of debts, they could be what happens is there will be the debt will be valued at the point the person passed away, and if there's enough money in their estate, in their bank accounts or in their equity in the house to pay that back, normally the debtors will want it back.
So don't go and run up a huge credit card bill before you die thinking that you've got nothing to do with it.
It won't fall on the shoulders of the executors as individuals. The first thing will be they'll check if there's enough money in the deceased person's estate to pay it off. So,
and if there wasn't any money in there?
Then I shouldn't say this, but in a lot of cases they write it off. Okay. But I shouldn't really say that because it's hard work to go down that route.
And most of the time people have some form of asset, whether it's property or money in the bank or car, it's something, and it's, I suppose, you don't want to leave that to chance either. You don't want to sort of end up running up someone's a big credit card debt and leaving it to someone, especially if you love them, and that's the whole point of like these things. You want to leave stuff to people you love, not make it really horrible for them.
I mean, one of the other debts that is quite important is funeral expenses. So it's always
how does that work? Tell us a little bit about what happens in terms of...
It's a bit doom and gloom, isn't it? But with funeral expenses, that is an expense of your estate. So it's not something that's passed on to your beneficiaries or your next of kin to pay. It's something that's meant to be paid from your money, whether it be from your equity in a house or your money in the bank. If there's not enough to pay for that, that's where we get into a bit of a sticky situation, and you might have to go down the route of applying for a state-funded funeral, which isn't particularly wonderful, and it's probably a no-thrill sort of funeral. So our recommendation is to perhaps look into, if you feel like being proactive and you want to take control and plan for what is an inevitability, pay for your funeral in advance, take out what we call a funeral plan. You get to then book all the details, you get to decide.
This is something I haven't done yet, so maybe I'll have to consider that, because you do think, I mean, I had this when my mum passed away, and obviously we used her sort of money to do that, but you don't really think about the funeral costs, and actually they are sometimes can be quite a lot, especially if you want, I suppose, 7 coffins and cars and flowers and all the other stuff. And just even having a general funeral is, it does cost money. So I think, I do hear of people who have gone, I've actually paid and sorted my funeral out and it's all done, and when I die, this is what's going to happen. So I think it's definitely something to consider. And I think it's really, I was laughing the other week with someone talking about this, and it's like you're sorting out your death admin, not your life admin, and it doesn't have to be morbid, it can be quite fun. And I've got a book, and again with in terms of funeral, my mum, when she passed away, she had already written down her wishes, which again, as much as we're saying about wishes and wants for an actual will, having your wishes for something like a funeral is also really, what songs do you want, what clothes do you want to be put in, what, who do you want there, like, do you want all of the family, or do you just want really close people? It can be quite, it can be hard, but actually it makes it so much easier. So as children of my mum, we could just look through her wishes and be like, this is what we're doing, rather than us having a fight over what we want and each of us having a different opinion of our mum. And, so it can be, really beneficial, I think, to think about these things as well as where your money's going to go.
Absolutely. And the families I've worked with, they're always so happy that someone has taken that weight off them, so they've made the decision. Because I often find when families are going through grieving processes, they don't want to be making decisions, and they're very much second guessing everything they're doing. They're very paranoid that they're not doing it right for the person who's died. Would they have wanted this? Would they have wanted that? If you make the decision, you take it off their shoulders, what is a really hard time already is made slightly easier for them.
Yeah, we would have struggled, because it's like, how do you choose music? Like, how do you people have their favourite songs, but then, as I say with my mum, there's 4 girls, like, it was 4 of us. We would have all had probably a different song that represented our relationship with our mother, so it would have been very hard.
It would have been very difficult, yeah.
I think, I think she actually, she enjoyed writing her own, because there was some funny things in there as well, and it ended up being quite a laugh just even looking at what her wishes were. So it can be, it doesn't have to be a really morbid affair, and actually if you sit down with, some friends and have a bottle of wine one night and discuss what you want and write it down, then at least it kind of makes it very clear on, everyone knows where they stand with it. And some people don't want a funeral, and that's also, I think, really, really key to, I suppose, portray to people, because actually you might not want a funeral and you don't want all the fuss, and that's fine. But if they don't know that, then they're probably going to think that you do and go down that route.
Absolutely, yeah. It's becoming increasingly popular to have what you call like an eco burial, where there's no service of any kind, and you're sort of
just
buried
a big party.
A big party, yeah. You're maybe buried in like a sort of eco wicker coffin. I've seen a lot of those at the Colney Woodland Burial Park. I've had very unusual requests from things like they want to be cremated and their ashes put into a firework and then set fire to illuminate the sky. And I've had one once his body cast on a Viking burial ship out at sea. I mean, I've had all sorts of things, but
I need to get more adventurous. I'm just thinking a coffin.
Yeah, don't wear a coffin.
On a bit of firework.
Exactly, very popular indeed. I mean, some people don't like the idea of their ashes being scattered. They think, oh gosh, where are they going? But some people want them, want them buried below a tree that turns into something beautiful.
Yeah.
So many modern requests nowadays. Don't just stick with the basic coffin. Think wider.
So while we're just on the subject of the death, what happens? So once the person has died, where and how does the will get sort of read and obviously brought to attention? Because it's quite a painful process, obviously, losing someone. So you maybe don't think instantly what happens, but how does that work?
Absolutely, good question. So we offer a very supportive bereavement service here. So when we are informed of someone passing who's a client of our firm, we would invite you in for an appointment in whatever means you wish to come in, whether it be a Zoom, a telephone, or a face-to-face, and we won't do a formal will reading like you might see in the movies, but we'll go through the will very carefully, make sure you understand what's in it. So we'll want to meet with the executors. They're the ones who are obviously in charge. Beneficiaries can attend if they want to, and we'll go through everything. We'll give them advice about how to do it, what the process will be, and then they can make a decision if they want to either pass it to us, and we'll do all of that work for them. We'll do everything from insuring the property if there's an empty property, we can even register the death, we can organise the funeral, we can do anything for you that you ask after someone's passed away, as long as you give us that authority to do it. Some people are really, you know, in grief we find some people are really proactive and they want to sort of be busy. So some people want to go off and take the advice and then go off and do it themselves. That's absolutely fine as well. We support whatever way suits you best, but often we find they then come back if there are some more complicated bits, you know, or things get a bit rocky along the way. So we will do whatever you like. We offer a bespoke service. So yes, it's up to you what you need. So,
Great. I think, I mean, is there anything that you feel that we haven't discussed? Is there any more questions, firstly, from everybody who's watching? And thank you for obviously joining us on this conversation. We have discussed obviously quite a lot of parts of the will, but if there's anything, you think of, or as I say, any more questions, because it is such a complicated, as I say, process that we kind of, no one really thinks about until you may be poorly, or, you know, because you kind of, this is the other thing, do you have to have a will if you own a house?
You don't have to. Okay. You don't have to at all, but it obviously is
much more complicated.
Absolutely.
Because I hear that sort of most people who I speak to say, "Oh, I got my will when I bought a house." So if you don't own a house, like I don't own a house, I suppose that's the point, that you maybe don't think about it. But it's very complicated. However, as you say, people like yourselves who understand it and know it just make it far easier and less stressful, and make it a simple process that we can all actually access.
Absolutely, yeah, definitely. And it isn't a scary process, I promise. You know, we maybe spend an hour with you talking it through. Hopefully, you know, we're all a really friendly team. We've got sort of 5 lawyers in our team. We're all really friendly, all sort of qualified in bereavement services as well. So we're here on hand to help. What is, you know, I suppose it's seen as quite a difficult situation. We're here to make it a little bit easier and lighten your load a bit. So,
and I think that's the thing with anything to do with, like for me, when I first obviously found out I was poorly, you know, you kind of think, oh, I'll put all these things off, but actually once you've done them, it makes you, I suppose, your quality of life better, because you know there's things in place. So actually, like anything, it kind of makes you almost live longer, because you haven't got all this worry and this stress and this...
That's always one of my sayings. It can extend your life. It takes a little stress away from you. I mean, there is that myth of, you know, if I go and get my will, I'm just going to go straight down, you know, everything's going to go downhill from here. But that's not the case. You know, doing your will means you're taking control, you're lightening your load. You might end up having a little bit more, you know, more time, more stress-free time, you know, to think about other things, the important stuff, spending time with your loved ones. You do not want to be thinking about making a will at the very last minute. I've done it before with clients, and it's such a stressful thing for them. They're not well. They're not wanting to sit still and listen for things. You know, they're in and out of consciousness. It's not a nice experience, and I always feel awful when I have to sort of try and wake them up again. And I can see their families are there wanting to spend time with them. It's a really...
you don't want to be kind of hassling at that point, do you? You don't want to be the one, because obviously it is so important you spend those sort of last few days with close people, and not sort of having to do all this stuff, which actually, you know, isn't then... It kind of makes it a much more stressful, not very nice experience.
Oh, I've just seen a really nice comment just there saying, thank you so much, really appreciate it. That's so lovely. Thank you.
There was another little quick. I've been informed that a living will is not popular, especially if you have a DNR and LPA.
So a living will is very similar to the new health and welfare power of attorney. So we recommend you don't necessarily need a living will if you've got health and welfare power of attorneys. So a living will is really just, like it says, it's almost like it's a document that where you can list what you want to happen, and it's normally reserved for sort of medical treatment and health decisions.
While you're alive still.
Exactly right. So it could say things from DNR to no organ transplantation, or you don't want to have your life artificially maintained. Those sorts of decisions. But our recommendation is, if you've got a health and welfare lasting power of attorney, so that means it's got someone appointed who can make the health decisions for you, they will be able to do that and act in your best interest. So you don't need to write down everything you want to happen. You just need to have the conversation with them. whenever you're ready, and then when the time comes, if the time comes, they will be prepared. So there's no need to list everything down. It's quite restrictive to have a living will in a sense, because you're writing all these things down that you want, whereas actually you don't know if in the given circumstance that might be best for you or not. It's sometimes best just to leave it in the hands of somebody else to do that. So yeah.
Was there any more questions? We did just have someone say they haven't done a will and they're going to come and see you. So we were just going to say that off the back of this conversation, I'll make sure it's written in the captions as well. But Foster's and the lovely Rachel have decided that anyone that books a will through the code Little Lifts 22 is going to mean that 10% will get donated to Little Lifts, the charity, which is incredible because we absolutely love Little Lifts. I'm an ambassador for them and they're just amazing, and it's really lovely that there's going to be some help. So if anyone does come and see the lovely guys at Foster's, you don't have to be Norwich based. As Rachel was saying earlier, you can actually do the conversations via sort of Zoom or telephone, and maybe pop in at some point in the future if you can do. But obviously, you know, if you want to do it, you don't have to be a local person. And they just, as I say, it takes the stress off. So if you are thinking of it, make sure you give them a call or a message. I'll put all the details, but if you want to tell us your email address.
You can get in touch by contacting either by telephone our main hotline, which is 01603 620 508. You can go on our website and you can get a free online quote. Obviously the discount with the 10% won't show on the quote, but we will make sure that happens. And the web address is www.fosters-solicitors.co.uk. I'm Rachel Chiarotti, so my email is rchiarotti, which is CHIAROTTI @fosters-solicitors.co.uk.
And we'll write all of that in the caption at the bottom so you can obviously see it clearly for yourselves. And if you did have any more questions, or you just want to have a chat to just find out a bit more information, then you're always willing to have those discussions, because I think, you know, it is a complicated process that can be made very uncomplicated by people who really know what they ask. Oh, can I still ask a question? Of course you can, my lovely. If you get a question in, we're still here, so please pop your question in the box if you do have one. We will stay on for a few more minutes, just in case there are any more. But it's been great, you know, obviously chatting. It's been really lovely. Good conversation. I hope, you know, on behalf of everyone that's followed today, and hopefully that people will catch up with us as well, that it's going to be a really insightful conversation that people are going to get a lot of help and just comfort from, knowing that how to go about these processes.
Definitely, and the aim is to lift the veil of uncertainty and take control. So
life is always very uncertain. Like it's oh my goodness, especially when you're living, you know, with a disease like secondary cancer. It just, so many things are complicated, and you sort of, you know, you're thrown from pillar to post with all the medical questions and the things.
It's just, I'm so it must be an absolute minefield, and you don't want to have another thing to have to worry about, you know. And I say we are very flexible. We work with you. So if you're having a bad day, you know, you've had chemo, you're on the sofa, we can come and see you at home. So
which is lovely.
Yeah.
So the question was, I have a will already, but would like to. Oh, hang on, it's just jumped. Would like to add something. Oh, hang on. When I pass. Sorry, we're trying to read it. It's gone jumping. When I pass, I'd like half of the house to go to my kids. Is that easy to just add on?
Oh, okay. So
how does it work with like another law firm? If they've done the will, do they have to go back to that law firm?
That's a good question, definitely. So we would recommend, if you've got a will with an existing firm, it's probably best, because they've already spoken to you, they know you, to go back to them to adjust your will, but you absolutely don't have to. So we take over wills from other firms all the time. So if you were to come and see me, for example, I'd request your previous will from your solicitors. We would then marry it with your amendment, if it be a codicil, or we have to do a brand new will. So it's all in one place. There's no worries about someone coming across an old will and thinking it's valid. And with a change like that, it could be a little bit more complicated than you realise. So if you're going to leave your half in the house to your children, we've got to think about what would happen if, say, there was a relationship breakdown between your husband and your children. I'm sure there wouldn't be. We would just have to maybe think about putting protective measures in to make sure he was safeguarded living in the property. If he has his own house elsewhere, that's great. If he's got another house, that's a little bit simpler. if he relies on that house and you want to leave it to your children, we'd have to go through we'd have to give you a bit of advice on it, and then we would be able to put probably a new will in place, but maybe just a codicil. It just depends. I prefer new wills because it's much simpler.
You can just start from scratch, can't you? And just get it done. And sometimes actually, if you haven't done it for a while, then actually having just getting it written up fresh, because obviously some people might have had their will for 10-15 years, then you want to make sure that it's right for now and right for you in your situation.
Definitely. Well, we've got a question there, haven't we?
Oh.
I think.
Oh no, there's one in a minute. Hang on, I'm just going to quickly plug in. One of my phones is about to die, so I'm just going to quickly plug that in. This is very this is very professional. I'm sorry. Right, quickly. There was something here. Great piece of advice I was given was have the difficult conversations, RE wills and LPAs, and then go out for a nice meal. We need to have these conversations.
Oh,
we do. I think that's good advice. Get a bottle of wine, have a chat, get these conversations out in the open, because they're always, the thing is, they are conversations, and I talk about this quite a bit on my page, and it's like we're so scared to talk about death, even though death is one of those things that everybody is going to go through. It's not like you're going to get out of it. Unfortunately, we're all dying at some point. So why is it so taboo? Why don't we talk about death? Why don't we talk about what we want after we die? Because we're so, everyone talks about birth. Everyone's so excited about birth. I want to be excited about death because, it's going to happen one day. So let's just get excited by it, and let's just make it the best we can for ourselves, our loved ones, and everyone else.
Absolutely, absolutely.
Do you charge for home visits? I presume that's an extra. Do you charge an extra for home
We
visit?
normally do, yes. So I know it sounds a little bit unfair, but we do normally charge for a home visit. So if you're within a sort of 10-mile radius of the office, there's a fixed cost of £50 plus VAT. If it's any further, then we would probably have to we discuss it with you and negotiate somehow with you on that. But if getting into the office is a difficulty, or you don't drive, we are right in the centre of Norwich with public transport, taxi service, everything at your beck and call. We also have ground floor meeting rooms if mobility is an issue. But we'd be happy to come and see you. So we could even meet you somewhere a bit closer if you want to go for a coffee or something like that. We don't often do off-site meetings, but I'm always open to it.
and as we said earlier, you don't have to come in person to sort the will. It's just easier. So you can do it virtually. So if you are London-based, Birmingham-based, Manchester, you can still talk to you guys and sort it out through Fosters, because I guess you don't want to sort of say to people you can't do it, because it's something that can still happen, can't it?
Absolutely, yeah. So we are very flexible. COVID has made us a lot more flexible, I'd say.
I think we've all had to, because a lot of in-person things haven't been able to happen. So I guess they have to be able to be done in the sort of legal way, but through. What process? So we've already gone through that in the live. What we will do is I will be saving this live to the page with all the details of how to get in touch, and the code for the Little List discount or the Little List contribution as well. So what you can do is, once I've saved it, if you listen back to the live, all the information about the prices will be on there. And if there's any other questions, obviously between now or any time, you can either ping them to me and I'll ask Rachel, or you can actually directly email Rachel and she will answer for you.
I want to be busy.
Give her a job to do.
Yeah, I'm fine with that, it's fine. Yeah.
But I don't even know how long we've been talking for. We've probably been talking for a very long time. So I think we're going to probably sign off now, but I just want to say a huge thank you to Rachel and the team at Fosters for having me in to have this conversation. I think it's been a really, really good insight into what happens, and I hope you found it really helpful, and hopefully we'll be able to go forward and maybe have more of these discussions in the future to bring up this conversation more.
Absolutely, it's been an absolute pleasure. Thank you for giving me the opportunity to talk to you all. It's been incredible. So I just hope to hear from you at some point. So
Brilliant.
Lovely. Thank you so much.
I'm going to sign off now. Thank you.
Bye.